So House Bill 16, this is the unattended dogs, extreme weather conditions, and heat. The House version was passed as introduced. You may recall the Senate version had a couple of amendments to it.
Conform to the Senate version, I suspect. All right. So moved. Seconded. So we are going to conform to the Senate. Let's hop over 83 for a second.
So House Bill 148?
Yep.
So House Bill 148, this is the definition of stalking. It clarified that stalking could be done, a violation could occur through electronic means. The difference between the House version and the Senate version had some clarifying language in it that the House version did not.
Motion to conform.
We are now on Senate or House Bill 153.
Okay, and Senator Lee wants to be against.
So there's a motion to
To conform.
conform to the Senate.
Anybody else?
So,
Lee and Huddleman are against conforming it.
okay. Let's just stay with Jamie. Jamie, want to go to 284? Senate, House Bill 284?
I got
Oh,
you.
no, sorry.
But are you both for the bill? Do you want to be recorded? So the motion would be favorable with amendments. So you're against the amendment, but are you for the bill?
I'm against the Senate amendments, but for the bill.
Right, yeah.
Is that what your two shows?
So we're just sticking with Jamie, so we're going to go to House Bill 284.
So,
He's going to read it.
House Bill 284, Council and the Judiciary flagged this for me. So the two versions were actually originally drafted slightly differently. There was it's a small technical difference on page 2, line 21. Both counsel over there and I agreed that the language that the House version has is probably better, just stylistically. But there is a difference between them. So if you go to House Bill 284, if you're looking at page 2, line 21, between the two bills, the language says in line 21, is the alleged victim or a witness in a case before the court concerning a crime of violence as defined in 14-101 of the criminal law article, or if you go to the same page in line in the Senate version. Oh, sorry, that's Senate Bill 20. If you look at House Bill 284, right, it says it's a difference between the and, so it's, we're just changing an article there.
Okay, let's change it.
Well, so it's up to the committee, but it seemed like stylistically an alleged victim or a witness in a case before the court kind contemplated that there could be more than one. So that seemed a little bit more encompassing.
Line 18 on page 2?
Line 21, they're both in line 21 on page 2.
One's an and and one's a the.
Of course,
Was Anna legislative?
be admissible.
See you right. Hold on, just want to check what the vote was.
Line 21, 2 places in line 8. So it also occurs in 2 places in line 8 as well. But yeah, let me pull up the vote.
It was unanimous,
Oh, it was?
yeah.
So it was unanimous.
So the motion's for favorable of the House version. Is everyone fine? Okay.
House Bill 441.
Yeah. House Bill 441.
So the House version of this is different than the Senate version. You may recall that the Senate version of this was actually turned into a Baltimore Courts and Criminal Justice package that included, among other provisions, firearms reporting in Baltimore City, and also included the District Court Jobs Court pilot program in Baltimore City. Insofar as the pretrial release notification, this is the provision that would require Department of Public Safety to notify BPD within a certain period of time of a criminal defendant's release that they had been released. There are differences just to those between those provisions in the Senate and House versions. This version still provides that it happens within 48 hours. The Senate version provided that it happens within 24 hours. And the Senate version also contained language that talked about the format that it needed to be provided in so that it would be searchable and filterable, right?
So since we like a kind of an omnibus bill, how does this work? If we conform the House to the Senate, how does that work? Because it's subsumed into another bill, so how does that work?
Right, so assuming that both bills pass and the provisions of that are being affected are identical, there isn't an issue. The problem comes up if you pass both bills and both get signed into law, and like let's just say for the pretrial release,
One's different than
one's different than the other, right?
So do we have
Motion to conform. I think the answer to your question is, I mean, you have to have a conversation with the chair of the other committee.
Which Senate version are we conforming it to?
got
Next one is House Bill 645. There's just a minor technical difference between the two amendments that the House and Senate versions, otherwise they're substantively identical. There's a set of commas that is in the Senate version that isn't in the House version. I checked with editing, and they said that stylistically, the going without the commas is probably better. It would just be, if you wanted to go that route, it would be going favorable on 645.
Second. Is everyone okay? I think it was a unanimous vote, right? All right, are you off? Is that you? All right, let's just go ahead and get after it with House Bill 83.
So with House Bill 83, there is an amendment in your packet. So I'm going to talk about, there's three different versions of this bill. This is the marriage age requirement bill. So first I'm going to go over the Senate bill, which we do not have. Then I'll go over the House bill version that we do have. And then I'll also go over the amendment in your packet, which is presented by Senator Elfreth, who is the sponsor of the Senate bill. Okay, so both the House bill and the Senate bill, in the amendment, they prohibit an individual under the age of 17 from marrying and strike emancipation from the bill with limited exceptions. So the Senate bill that passed out of the Senate, so an individual who's 17 years old may not marry unless the individual has the consent of a parent or guardian or the woman to be married is pregnant. So this matches up to current law if a 17-year-old were to wish to marry. A minor who is married may file an action for divorce and is deemed emancipated for the limited purpose of obtaining a divorce. So the House did amend Senate Bill 29 to match the House version, and I don't know if it's on its third reading or if that might have been yesterday. Right, we have the not concur report for that. So then going to House Bill 83, which is also how the House amended the Senate bill. So an individual who's 17 years old may not marry unless the individual presents a certified copy of an order granting authorization to marry, and the other individual not to be married is not more than 4 years older than the individual. The bill also keeps in the hearing process it had for the order to marry and emancipation order. It just strikes the emancipation portion, so you're still going through that whole process of having an attorney appointed, having a hearing with the parents or guardians present. The bill also required the court to provide information relating to the impacts and outcomes of child marriage in the United States and notify each living parent, guardian, or legal custodian of their legal right to support or oppose the petition to marry. Also, this is slightly different than the Senate bill again. A minor who is married may file an action for divorce and then also sign and enter into contracts. That sign and enter into contracts is not limited to divorce, it's just a sign and enter into contracts. And then now I'm shifting to the amendment that is in your packet from Senator Elfreth. So this amendment uses the House bill as the basis. So it deletes the requirement that the other party to be married is not more than 4 years older than the individual. And then it states that if an individual is an out-of-state resident, they must meet the age requirements of the state that they're a resident of. So if a 17-year-old is a resident of a state that prohibits marriage to an individual who's under 18, that individual cannot get married in Maryland. And then if an individual is 16 from a state that allows a 16-year-old to get married and comes to Maryland, that individual has to obey Maryland law and cannot get married in Maryland. So you have to be 17 at a minimum, and then also from a state that allows a 17-year-old to get married. But otherwise, it matches up to the House bill still. And that is, it had to do with a proposed amendment, or it didn't come out as an amendment, it was discussed on the Senate floor. Yeah, and that was a way to try to make it still be constitutional.
Why is it?
I was just to say.
You could honor a marriage certificate from another state. You just couldn't get married in Maryland.
The version that I was just discussing about the out-of-state, in-state part, that is for the proposed amendment submitted by Senator Elfreth. The one that was passed by the House is the one that still has the, that hearing process that was in the original bill that the Senate struck.
All versions of the bill have 17 as
Yes.
the right line bar.
Correct.
But the House version of the bill still puts in a hearing process and an emancipation process,
No,
a divorce process.
so all bills strike, if a 17-year-old gets married, they're not emancipated. However, all bills allow a 17-year-old who gets married to file for divorce, and the House bill also allows them to contract. So it's like a partial emancipation,
bill-
if you want to call it that way.
Says 4 years.
House bill is 4 years. The amendment strikes the 4 years requirement. The Senate bill did not have the 4-year
So
requirement.
4 years, like, within 4 years or 4 years and under, it's under 4 years?
A 17-year-old cannot marry someone who's more than 4 years older than them.
Thanks.
Why? Why? That never, I mean, so here's the problem. You know, it's like we made a deal on this, a card laid is a card played. I don't appreciate then there's new amendments coming in. The bill barely passed the floor. Had we not done this agreement and had, quite frankly, had I got up and said, we're siding with the members on the other side, and our caucus would have killed that bill. I mean, it was going down. That thing barely got through. So that 16-year-old amendment almost took this thing down. I don't know why when you have a bill that barely gets through like this, you've got a Senate sponsor now coming in with additional verbiage, and then you've got a House language that is additionally complicates it. We never discussed this 4-year age gap. That was never brought in. I mean, my sense is this thing barely got through the floor, and they're lucky what we got through. It was an agreement. Was the House not party to what we agreed on and signed off? Because when that thing went to the floor, I was told the Senate sponsor was good with it. And I don't know why the Senate sponsor's coming in now with additional amendments. And then the House, did they not agree on this? We don't know. I mean, I kind of feel like we did our work, we barely got a bill through, we did an agreement, and I think it's up to the Senate sponsor to work that out with the House. And we could always go to conference, but I just think a bill like this, I mean,
This change on page 8, lines 24 and 25, this is new as well. I mean, just allowing a minor to contract and be, I guess, held accountable for anything. I don't like that.
I'd like to speak about the bill. So certainly I was not party to any agreement about the bill. I never agreed or thought that the bright line of 17 was the proper policy for Maryland. I still don't. I look at this as an opportunity for everybody to have real input and to push forth the policy that we believe in and that we think is the best policy for Maryland. Nobody wants this, inflammatory, provocative concept of child marriage, coerced marriage. But we know from the numbers, it's not a real thing here now, and we don't want it to be. So we should take precautions to make sure that it doesn't develop into something that's a real problem. We should put restrictions on minors being married. I've never believed that 17 is the bright line 17 is the proper solution. I am very concerned about a 16-and-a-half-year-old that's dating a 17-year-old that has a child together, and they are now able to co-parent, but limited and unable to marry. It's not a very popular concept these days, this idea of marriage coming before the child thing, but there are still people, and I've heard talk about Catholics and religious people. I'm not Catholic, I'm not hyper-religious, but in the culture that I was raised in, the family environment I was raised in, that would have been a deal breaker. I would not have been able to have a child outside of marriage and still continue to be a part of my family, I don't believe. And so we talk about these coercive parents, and, you know, we talk about these coercive marriages. There are all kinds of situations. There are children that come from great supportive homes. There are children that come from abusive homes. There are parents that are wonderful. There are parents that are terrible. When we make these bright lines that don't make any exceptions for individual circumstances, I think that's the problem. And so if in an ideal world, if I were allowed to make policy that I would be comfortable with, that I think is good, I would put the bright line at 16 or 16 and a half. I would make exceptions for parental consent and or parenthood or expectant parenthood. And I would probably opt for the version that does require some eyes on it. I don't know that I would restrict the age of the other partner, but I would say that, yeah, let the court sign off on it, because that way, if there is a concern about a 16-year-old marrying a 45-year-old predator, then a judge would have the ability to take a look at that and decline the marriage petition. To just say 17, we're not doing anything, because it's a 17-year-old could still be marrying the 50-year-old predator under the law that we passed in the Senate. So I do not favor any version that I've heard. I favor a version that would lower the age back to 16, or 16 and a half I could live with, and that would allow a court to have eyes on these marriages to make sure that someone's not being a victim of predation or coercion, and I would allow for those exceptions for if you are a parent or expectant parent, or, I don't know, I mean, frankly, I would allow for if you just want to. But I could live with those restrictions, and since we have it back on the table, and frankly, I don't think any version is ideal, I would like to do it. I absolutely don't agree that we should use this bill as a vehicle to expand right to contract for minors. That's kind of outrageous. And so those are my opinions, and I'd like to hear from other people.
I think that there is consensus on both bills that 17 is the number. So I would think that we should stick with that, just because each side has sort of made peace with that.
But we've only made peace with that because of that bill. But if we're going to start changing the other terms of the bill, then that consensus just went away.
Well, I would say that, for me, that would be the lowest I would go. But I think I agree with Jill about the court having eyes, that if, that would be, that could be a piece that we pull back in. So that if there are alarm bells, you know, about a big age range, since we don't have the 4-year spread in there, that the court at least has another set of eyes to be able to review and make sure it's not an abusive kind of relationship. So I think at a minimum, we should be able to, I would urge us to keep that in.
So, I mean, just to shorten this up, I mean, talk about the politics of it. This bill has been around year after year after year. It sails through the House every single year. It's over here where it runs into problems. And I've been one of the main opponents. There's others on here. There's been bipartisan opposition to this. We made an agreement. We cut it. We got it out of the Senate. They should be very happy that it came out of the Senate, because it has not, this has been the stumbling block year after year, is this chamber. And so what my suggestion is not to concur and let's go from there, because the Senate, we did a bill, there was a compromise in place. I don't think we need to sit here and haggle over new language and refight this whole thing out. Do it in conference, or the House can just take our bill. They should, because, I mean, it's died every year over here. If I was them, I would take our bill. These are superfluous, these aren't big issues, but whatever, or go to conference. Favorable with amendments so that the House bill looks like the Senate bill.
Second.
No, as passed by the Senate. 'Cause
So you vote, so there's two steps to the process. So first you have to vote to amend the House bill
to look like the Senate.
to look like the Senate bill, and then the second is the motion for a favorable with amendments. And then there's a third step, because we have the concur, not concur. So then we would vote to not concur. Is everyone for all three of those things?
I'm not for it, but I could.
Which part are you not for? All of it, all three?
Why, you would want ours there.
I know, I mean, well, go ahead.
Are you for the amendment to amend the House bill to the Senate bill?
Because that'll, I guess, probably force conference, yeah, but I didn't ever agree to this number like this.
You should like our position to go to conference.
I got you, all right.
Okay, do you want to be recorded in the green for favorable with amendments?
I want to be recorded as a coerced verb.
Under duress.
That's hilarious.
All right, and then for the concur, not concur, you're good to not concur. You're a yay for not concurring, okay.
That's an aggressive move. Go to conference. You can always stand up at conference. Killing the House bills are really aggressive.
Kill the House,
move.
we've never
I think
That would be a savage move.
Do you want to appoint conferees?
House Bill 349.
So with House Bill 349, this is the cross file to the small claims examination and aid of enforcement. So there is an amendment in your packet. So the House passed this bill clean. The Senate passed it to prohibit the court from ordering the appearance of an individual for an examination and aid of enforcement of a money judgment in a small claim action. The OAG, after it was passed by the Senate, noted that there's another way for an individual to be arrested during the discovery process for aid of enforcement, and that is if an individual, the creditor, sends the debtor a set of 15 questions, written interrogatories. The debtor has 15 days to respond. If the debtor does not respond, the creditor may go to court requesting an order that the debtor respond. The debtor, once that order goes into effect, has, again, 15 days to respond. At that time, if the creditor doesn't get any information from the debtor, the creditor can go back to the court, say they did not get the information, the debtor disobeyed a court order, and then at that time, the debtor could be arrested. A body attachment could be issued for that individual. There's no requirement that the debtor then go for the aid of the examination in court. They can do either or, they can do both. So the proposed amendment, which was also offered in the House, would close that interrogatories loophole. So that way, the individual cannot be, or the court cannot order the individual to appear in court for aid of execution, which is what the bill already does, and the court cannot order the individual respond to interrogatories.
How do we change our Senate bill to make it like the House?
So the Senate bill is in the House right now. The hearing was earlier this week. The same amendment was, the amendments were offered over there.
So we're going to accept the House bill. We're going to pass the House
So no, what we would do is amend the House bill to match the Senate bill as passed by the Senate with this amendment that I just went over to cover the written interrogatories.
bill. So this amendment wasn't in the House bill?
No, I offered, it was not in the House bill or the Senate bill. Okay? So when I had the hearing, I offered it when I had the hearing.
All the time, because if you answer those, you don't have to come in. And so so what you said is, the whole rationale on the first bill, on the way the bill came in originally, was that if I have to appear for the examination, I have to take off from work, get a bus, ride across the county, go to the court, sit down, wait in court for an hour, do this examination, get back on the bus, and now after 5 hours to answer your oral examination, I had to miss a day of work, I'm really screwed. The interrogatories are, you mail it to them in the mail, their standard district court form, they get it in the mail, they have whatever, probably 30 days to return it and mail it back. It's just. And do they do it? Yeah, because they don't want to get on the bus and come to court. So yeah, it's commonly done. It's not, we put that into effect like, I don't know, 5 or 6 years ago. That was the compromise so that people didn't get arrested, was to give them, you give the opportunity to do the interrogatories.
I don't know, Bob, in 4 years of practicing law, I don't think I ever got useful answers to interrogatories.
Chris, that's because you're talking big circuit court cases on complex issues. These are real simple. Where do you work? Where do you live?
Okay.
What's your full name? It's a standard district court. They're not, you don't get to ask, it's a standard district court form. Where do you bank? I mean, it's nothing
Oh, he's
possibly get. So, people vote what they want. I just wanted to pitch that in because at some point, people have to play the game. You're either part of society or you're not. I mean, for God's sake, you want all the benefits of purchasing things in a society and running up debt in a society, but then when society says, hey, where do you work? You're saying, oh, I don't really want to be part of the society right now. It's not really convenient to me. But whatever.
So if the amendment is accepted, the process that's still available to the creditor is they can send the debtor an information sheet. This is a sheet that is created by the district court. A list of questions where the creditor can then cross out certain sections, but they cannot add anything into that. If the debtor answers the information sheet, which includes where do you work, where are you banking, information like that, the creditor cannot then do the interrogatories or the aid of execution for a year. If the debtor does not respond to the information sheet or it's incomplete, at that time, the creditor, after a certain amount of days, they don't have to send the information sheet, then they can do the written interrogatories, and that's when they create their 15 questions. So under the bills, they still have the option to do the information sheet, written interrogatories, and/or the aid of execution. But just for the later two, the interrogatories and aid of execution, they cannot be ordered to do it. Information sheet was always voluntary.
Here's the problem. The whole purpose of the bill is to make sure someone doesn't go to jail over a small amount of money. So if the person doesn't answer the interrogatories, if we preclude jail as an enforcement tool, what enforcement tool is there to require someone to answer these interrogatories? Suppose they know they can't go to jail, Bob, and they don't answer the interrogatories. What can be done?
That's my point, is that the amendment would say, you don't do anything. You get a judgment and you go figure out how to get the money. There is no way to find anything about. You said, the information sheet's voluntary. The interrogatories, you can't, there's no tooth behind it. Why would I comply?
Right.
There's no negative ramification, and then the oral examination.
And wasn't the testimony to the effect that these days, people just pay $50
He's about to just say that,
these
yeah.
reporting agencies, and they get all that information.
That's what the testimony was. That's what the huge debt collection, Visa and those kind of people do, because they own the damn companies. But the smaller guys don't do that, because
Small attorneys can't use those companies
you'd
for
have to
$50?
sign up.
Huh?
No, it's not just you'd have to get their full credit history and everything. They don't have access to all the high-speed shit. This is local people, local debt. Somebody owes for $4,000. They actually use the interrogatories. Hey,
Yeah,
whatever the committee wants to
no,
do,
no,
I'm just
I'm-
voicing my opposition.
No, I hear you. No, Chris, I was with you. I think all the information you need is easily ascertainable through those services that you can get online very
That was my
easily. It's
impression.
actually probably and much more accurate. So, I don't know.
Bob's saying that
The smaller,
lawyers-
yeah, yeah.
small lawyers can't use the
Smaller-
services, is that?
Oh, and they find this very helpful, and they also use this to meet with the creditor, the debtor, and work out a payment plan, and they don't then have to.
When they come up with a solution, of an enforcement solution, other than putting the person in jail for owing $2,500.
Motions to adopt the amendments.
To
I'm
conform it to the House and adopt the amendments, right?
No.
No. I mean, conform it to the Senate and adopt, or are you taking the House first?
It would be a brand new amendment.
Brand new
Yeah,
amendment.
just-
Sorry, got it.
Sorry.
It's in second. Is everyone
I'm down.
down?
Oh, I'm with Cassidy down.
Huff and Bailey. Okay.
What about is West?
He's with. He's up.
Okay.
All right. All right, the motion's favorable with amendment. Same vote. Same vote.
Isn't that the same?
Bill's 369. So this bill establishes procedures for the issuance of a new marriage record when the name of a party to the marriage has been changed. The bills are not identical. There's a small difference. The House bill requires a substitute marriage record to be in electronic format. not paper format. The reason is because the county clerks requested this change because they're going to be the ones tasked with implementing the bill. They were concerned about having to go back and change paper records, which would either be difficult or impossible. Senator Lee is the sponsor of the Senate bill, and they are in favor of these amendments. I believe the same amendments are being offered on Senator Lee's bill in the House. So it would be a favorable.
Second? Is there a second? Is everyone okay with that? Okay, so now the bill is before you with
No,
amend,
the motion was favorable.
didn't we adopt an amendment?
You don't need to adopt any amendments.
They're adopting the House, got it. I know, I'm like, it's like, all right, so the House is adopting the amendments that will make this look, to make that version look like this.
Yeah, the House
Got
will
it.
make the amendments, and then we'll just concur when it comes over.
Got it, understood, okay.
And I'm voting no on the bill.
Council's no on the bill?
Hold on.